Assignments page wise. Page 5, till number 19. Page 6, till number 20 to 27.
What do you want? Request of learned counsel for appellate released after 2 weeks. Request counsel for your for appellate released after 2 weeks. Request of counsel for appellant release next week. Request released after 2 weeks. Yeah. Oh, that's good. 2 weeks. 2 weeks.
Page number 7, till number 28 to 30. Number 30.
Your number?
30.
Your correspondent. Request of counsel correspondent released week after next.
Page 8, till number 31 to 36.
Which counsel for appellant released after the Dasara vacation. Request of counsel for appellant released after the Dasara vacation.
Page number 9, till number 37. Number 1,
Or do you have it tomorrow? The hearing is supposed to be today. Let it come at the paper. You filed it already. Let it come. Yesterday. Earlier. Same. Passover. Senate counsel for the petitioner signed a memo along with the citation having been taken out in the newspaper publication of Indian Express and Lok Sabha of Mumbai edition dated 21/9/23. Same is accepted. There is no rival claims. This matter for inquiry. It's what? Probate of will. Huh? this matter after 2 weeks for inquiry. Para 9.
On overview after the education bill. Probably let's find the values. 4 or 5 value, coming together, coming daily. By activity looking for in making it feel and previous academics are not known. Previous academics are forthcoming context where tradition files for probate to regular reviews. Here I am seeking revocation of probate to regular reviews. And in fact, I have this is the attend this meeting. Both academics I have produced at page 113, 116. These were academics submitted to the coverage and registration. We expect the evaluation. Finally, I have expectation this matter the revocation is not taken over. That by urgency. In my daily correspondence with the respondent, he had informed me that he is in the process of taking over the file. For the request to go to and to be but application date on violation that we need to make.
What interim?
See of the operation of letters of communication granted in
But where is your original bill?
I produced it and page 105.
The certified copy. Where is it?
I think
Take it. I'll list it tomorrow or something.
Tomorrow.
Let counsel for the petitioner is present before the court. He submits that with regard to the objections raised by the registry, the objections raised at serial number 7 and 8, 7, 8, and 10 could not survive for consideration in view of the fact that the present petition is filed for revocation of the rebate. The Matters of Administration granted in probate CP number 18 of 2019. Therefore, he seeks indulgence of this court to overrule the objections raised by the registry at 7, 8, and 10, accepting the same. The objections raised by the registry at 7, 8, and 10 are overruled. With regard to the original will to be handed over to the safe custody, the counsel is directed to produce the original will. We list this matter tomorrow, 11th.
But why?
Counsel takes a week's time to carry out the amendment and file the amended cost type. Same is granted. The counsel submits, or the appellant submits, he will do the needful during course of the day. Bail list after 2 weeks. Carried out the amendment. Have you carried out the amendment? What about notice to R3? You're not. It will not arise. In view of learned counsel G.A. Vishwanath Reddy, having filed wakalat for proposed R3A to D, question of furnishing protest fee and correct address will not arise. Week's time granted at request of counsel for appellate to find the amended court title and carry out the amendment. 2 weeks. For the appellant seeks time to take necessary steps in respect of the deceased appellant. 1A and 1A. List after 2 weeks. The representation on either side, released after 2 weeks. Two weeks time granted if needful done issue notice to R2. Weeks time granted to file papers.
Sorry, HR.
No representation on either side. 2 weeks time granted to take necessary steps for unserved respondents R6, 8, and 11. ಯಾರಿಗೆ paper publication? Huh? At request of counsel for appellant 2 weeks time granted. Restrict. Taking of paper publication draft. They are not taken the draft. IE is allowed. Then you have to take out fresh. All right. Learned counsel to obtain is permitted to obtain fresh draft from the registry and publish the petition on or before. Pick it up. The appellant 2 weeks time is granted. Why don't you allow him to speak? For filing amended plaint, what is the difficulty? Huh? Counsel fee. Who's that related? Yes, what is your submission? Who are you appearing?
First actually they did the transition.
53 matter. Who are you? When you will write Learned counsel for the appellant is present 6 times to file the amended plaint. It's this matter after 2 weeks. Counsel for the respondents and the beneficiaries are present before the court.
Hearing on A. Meeting confirmed.
An additional affidavit, evidence, physical evidence will be considered along with it. You want to file objections? Why you have not filed till now? DVR. Learned counsel for the appellant and counsel for respondent are present. Counsel for respondent seeks time to file objections to IA 1, 2, and 3. relist for 2 weeks, week after next.
Yeah. Yeah.
Learned counsel for the appellant filed IE number 1 of 13, seeking to condone the delay of 3 days in filing the appeal. And perusal of the affidavit annexed to the application and satisfied with the reasons assigned in the affidavit annexed to the application, this court deems it appropriate to allow the application and condone the delay of 3 days in filing the appeal. Accordingly, IA 1 of 13 is allowed, delay of 3 days is condoned. As for admission,
Maybe.
all respondent. Notice of vacant. Issue notice on IA 1, 2, 3. What is this IA 1 of 21? So you want to withdraw that? Issue notice on IA 1, 2, 3 of 23. Full stop. Learned counsel for the appellant seeks to withdraw IA number 1 of 21 as not pressed. Placing a submission on record, IA 1 of 21 is dismissed as not pressed.
Number 17. Nineteen is Nagaraj.
Nagaraj, you pass over.
21.
21, I appear for the respondent, my lords.
Pass over ante Mr. Hosmat.
ಬೇಡ ಲಾಸ್ಟ್ ಟೈಮೇ ಬರಲಿಲ್ಲ ಅವರು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಕ್ಟ್ ಏನು ಬರೋಲ್ಲ ಅವರು ಲಾಸ್ಟ್ ಟೈಮು ಬಂದಿಲ್ಲ ದಟ್ಸ್ ವೈ ಇಟ್ ವಾಸ್ ಅರ್ಜೆಂಟ್ ಟು ಟುಡೇ
For the appellant is here.
Pardon?
Counsel for the appellant is here. All right, pass over.
My absence may be, my lord.
All right, no problem. Only
Please,
for
sir.
admission between the court
Please.
and appellant.
Please.
Number 24.
Friday ಏನ್ ಮಾಡ್ತೀರಾ? What's the urgency? What is the urgency? Argue them today. A list on 13th at request of the appellant. Also.
Arguments.
Yes, Pavan. All. Yes. All. The counsel for the appellant is present. He submits that there is that client is unable to come down to India to discuss the settlement process. He seeks a week's accommodation. Release this matter after the Sara vacation. So she's also come down from Canada. Germany. Already. After vacation. PFT. ಮುಗಿಸಿದಾರೆ ಕಂಪ್ಲೀಟೆಡ್. ಫಾಸ್ಟ್ ಬಂದಿದೆ ಒರಿಜಿನಲ್ ಫೈಲ್. That's it. You are supposed to file some application. Yes, Mr. Janardhan. What do you like to do in that? I think some amendments you are supposed to carry. So that is reflected in the sale deed. Your sale deed. Filed by the defendant.
Pass over.
Pretty much. That's right. Huh? Oh, so you're relying on his schedule. You're relying on their schedule. So the site number is 119 in both the case. No, in both the case site number is 119. Measurement also same. So,
One side.
ಅದನ್ನ ಮಾಡ್ಬೇಕು, ಅದು ಮಾಡಿಲ್ಲ. Learned counsel for the appellant submits. Where you want to carry out the correction? No, in which? In the plaint. What does your sale deed say? Not by the remaining portion of ಇನ್ನೊಂದ್ರಲ್ಲಿ Only it is. How is it divided into? It is divided from north to south or east to west. You don't know. To west is 30 feet. So the total measurement is what? 60 feet by 25 feet. Or it is 50 feet by 30 feet. Plain tell ಬರ್ದು ಎಲ್ಲೂ ಹೇಳಿಲ್ವಾ plain tell. ಅದರಲ್ಲೂ 30-25 ಇದೆ. Whether it is 30 by 50 or 60 by 25.
Each.
Of the exhibits originals. Original records very well. All right, the file has to come. Original that mistake ಆಗಿತ್ತಲ್ಲ. The file is coming. It will wait. So at least file an application or a application with one memorandum of facts. Password.
59.
Therefore, so you are the rival claimant. Who are you? So representation on behalf of appellant. Direct counsel for the respondent seeks time. Delist this matter after the Sara vacation. After vacation.
Section 32.
Your opponent, Dheeraj Kumar. Because
Yes, that's the capital filed challenging the disagreeing. The appellate appeal may not file there or alone. declaring that may not develop already a contract. And that may not be immediate must execute the well of the contract. Therefore, it is. Then the NSF may not file the appeal. Appeal was may not dismissed, responded appeal. Thereafter, may not
No, you said the suit for partition was filed by the respondent.
respondent, which was appeal.
So, and the appeal filed by you, it is set aside.
Yes, that's right. Then may not-
Second appeal. Second appeal filed by respondent is
That's right.
did not filed. So that has become final.
Respondent.
In the parties. All right. Let us see if he comes now.
Yes.
Pass over more. If he comes and says so, then it can be disposed of. Correct. So that has set aside the judgment and decree in favor of respondent. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅವರು. ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
Then 34. That's all passed.
ಪಾಸ್ ಓವರ್. ಸುನಿಲ್ ಪ್ರಸಾದ್ ಇದ್ದಾರೆ.
35. And Ramesha.
ಆಗಿದೆಯಾ? ಹೌದಾ? You Prakash has to argue. All right, we'll wait. Pass over ಮಾಡಿ. You are appellant. Huh? Who has moved? Then counsel for the appellant and respondent are present. In unison, they seek time. We list this matter after the Dasara vacation.
Clear? ಜಯಕೀರ್ತಿ ನಿಮ್ದು ಮುಗಿಸಿದ್ದೀರಾ ನೀವು? Both of you have completed it. ಮುಗ್ದಾಗಿದೆ. I know. Ha. Correct. ವಾರ.
Basically, now that he has filed this application for production of the document to show that site number, that survey number 177 and 267 are one and the same. And that issue, I think, has probably was not addressed in the correct, except for mention. Correct. All right. Now my question to you is, in view of this application which is filed now, whether both of you can go back and adduce evidence, whether if it, because that is the only thing which is. So that is the one which is going to clinch the issue, because it. No, it is their case even in the plaint that it is 160.
No, the one thing, paragraph 2 is the question, you know the process.
Who's in possession of this now property? They are claiming 4 acres 20 guntas. What is the document you have produced? RTC for 177 is 4 acres 20 guntas in your name, father's name. Huh?
Not ready to get the United States is correct and not.
Do you find objections to this? Huh? You relied on some judgments.
In 96. But the soul is since 1990. Even as on the date of death of the soul, the sentence in the third one comes from the number 296. The drop point is people to obtain the then
Please sit down. Sit down. In the written statement, have you contended that survey number 177 does not exist at all? Because your argument is these are two different properties. Whether in the written statement, have you taken up the plea that this survey number 177, which they say is converted to 267? Correct.
But they have not made any effort to fix the correct. The difference is also going to the documents. There's no, they have not denied the fact. No such suggestion.
Already, even if we agree to your contention, the fact remains that you are claiming only 267 to an extent of 1 acre, whereas he is claiming to an extent of 4 acres and 20 guntas. That is admitted. Because you are not claiming the entire 4 acres.
There are other.
All right.
Supervisor land. Whereas in paragraph number 2 of their examination sheet, they admit that I was permitted to blow the land, blow the blocks, and 50% of the block. The courts cannot from getting.
Of course, that you are right. That when the plaintiff comes before the court, the issues are also framed in such a manner which has to be proved by the plaintiff. If there is a defense taken which is contrary to that, then that will shift, burden will shift if he proves it.
The very specific way, defendant would have an opportunity. Now they are going to defend the issue of paper. It is important to the.
This appeal is preferred by the plaintiffs, being agreed by the judgment and decree dated 31/1/2007, passed by the Civil Judge Senior Division at Ramnagar in RA number 51 of 2006, whereby the first appellate court allowed the appeal preferred by the respondent bar defendant against the judgment and decree dated 19/4/2006, passed by the Civil Judge Junior Division in OS number 111 of 1996, whereby the learned trial judge decreed the suit of the appellant plaintiff. Full stop. Therefore, the appellant plaintiff is aggrieved by the judgment of the first appellate court in setting aside allowing the first appeal and dismissing the suit of the plaintiff. The parties to the proceedings shall be referred to as per their status and rank before the trial court for the sake of brevity. It is the case of the plaintiffs of late Lakshmamma and defendant number 4 Chaudamma are two wives of late Mugayya. Plaintiffs number 1 to 3 are the daughters of deceased Lakshmamma, who was the first wife of late Mugayya, son of late Jogayya. Since there was no male issues, the first wife, late Mugayya, married the fourth plaintiff, Chaudamma. But however, no male issue was born. The said Srimati Chaudamma, second wife of late Mugayya. Deceased Lakshmamma predeceased her husband Mugayya long ago. Thereby, agricultural land bearing survey number 177 in bracket old, new number 267, measuring to an extent of 4 acres 20 guntas, was purchased by late Mugayya under a registered sale deed dated 28/12/1948. File Exhibit P2 from one Tirumale Gowda, son of Channai Gowda, for a valid sale consideration. It is contended that since late Mugayya had no male issues, he settled the land during his lifetime, and out of 4 acres 20 guntas, 1 acre 20 guntas was given in favor of Chaudamma, the fourth plaintiff, and 1 acre each in favor of plaintiffs 1 to 3. However, the khata of the said property continued to remain in the name of late Mugayya. Late Mugayya was looking after the land in question for personal cultivation. But due to the fact that he developed old age ailments, the land in question was given to the defendant who's none other than the son of the vendor of late Mugaiya, to cultivate the land and hand over 50% of the food grains and hay stock grown in the land in question as contribution of the defendant, and the defendant was only acting as a supervisor and as a laborer, nothing more than that. It is also stated in the plaint that the property was given to defendant on Vara, V-A-R-A, even inverted comma, single, Vara basis. Being the state of affairs, next paragraph. This being the state of affairs, pursuant to the death of late Mugaiya, plaintiffs filed an application to the Tahsildar Ramanagaram to effect mutation of their name as per the shares given by late Mugaiya to the plaintiffs. And on the basis of the said application, his Tahsildar effected mutation, declaring the shares of the plaintiff pursuant to which the plaintiffs decided to terminate the so-called Vara to the defendant and consequently convened their decision to the defendant in the month of March 1996. And thereafter, the defendant, being agitated by the said termination of the Vara, started interfering with the plaintiff's peaceful possession, enjoyment of usurpatory property. Which forced the plaintiffs to file the suit. Original records Kodima. Original records.
On the basis of the said application, it considered effective the mutation, declaring the shares of the plaintiffs pursuant to which the plaintiffs decided to terminate the so-called vara, the defendants, and consequently conveyed their decision to the defendant in the month of March 1996. And thereafter, the defendant being legislated with the said termination of the vara, started interfering with the peaceful possession and enjoyment of the scheduled property, which proposed the plaintiff to file a suit.
For the relief of declaration, declaring the plaintiffs to be the absolute owners of suitable property, and for consequential relief of permanent injunction, restraining the defendants and his agents from interfering with the suitable property of the plaintiffs. Defendant on appearance filed a detailed written statement contending that the suit filed by the plaintiffs is not maintainable in law. And denied all other contentions made by the plaintiff in the plaint. It was contended by the defendant that the alleged sale deed, if any, in favor of the plaintiff father, was a concocted and got up document which was not acted upon. And that late Mugaya never acquired any right, title, or interest over the suit schedule property. So also, either late Mugaya or the plaintiffs never were in possession and never acquired a right, title, or interest over the suit schedule property. In effect, the plaintiff denied the averments made by the averments made in the plaint in toto. And the defendant took up the plea that the land bearing survey number 267 of Bilgumba in all measured 7 acres 31 guntas, including Kharab land of 11 guntas. It was further pleaded that this land bearing survey number 267 is an ancestral property of the defendant and his stepbrothers and father Thirumalai Gowda, amongst other properties. It was further pleaded that about 42 years ago, the oral partition had taken place, thereby dividing the properties of late Thirumala Gowda. And 1 acre 20 guntas had fallen to the share of each of the sons of late Thirumala Gowda. Accordingly, 1 acre 20 guntas of the northern side fell to the share of this defendant. Similarly, his other brothers and stepbrothers got 1 acre 20 guntas on the other side of the remaining property. Defendant very specifically pleaded that he was not a vara tenant of any portion of land in survey number 267 or any part of the suit schedule property at any time as contended and alleged by the plaintiffs. On the basis of these pleadings, the defendant sought for dismissal of the suit. On the basis of the pleadings before the trial court, relevant issues came to be framed by the learned trial judge, which are as under. In page 46, para number 9, issues number 1 to 6. Step 1. In order to substantiate the issues and establish the case, the plaintiff adduced evidence, and the first plaintiff examined herself as PW1, and one Lingaya examined himself as PW2. The plaintiff got exhibited 11 documents in the form of exhibit P1 to P11. Whereas on behalf of the defendant, his son Nagesh, being the power of attorney holder, examined himself as PW1 and got marked exhibits P1 to P7. Full stop. On the basis of the material evidence, both oral and documentary, and upon hearing the arguments of the learned counsel for the plaintiffs as well as the defendant, the trial court answered issues number 1, 2, 3 in the affirmative and negatived issues number 4 and 5. and decreed the suit of the plaintiff by declaring that the plaintiffs are the absolute owners in possession and enjoyment of the suit schedule property. Stop, the defendants were also restrained by an order of permanent injunction from interfering with the peaceful possession enjoyment of the plaintiffs over the suit schedule property. Para. Being aggrieved by the judgment and decree passed in favor of the plaintiffs by decreeing the suit, the defendant challenged the same in the first appeal in RA number 51 of 2006. Questioning the correctness and the legality of the judgment rendered by the trial court. Upon reconsideration, reappreciation, and reanalyzation of the entire materials on record, both oral and documentary, and the impugned judgment of the trial court, the first appellate court framed the following points for consideration. In page number 19, point number 1 to 4. The first appellate court, upon consideration of the entire materials on record and the arguments addressed by both the learned counsels for the plaintiff as well as the defendant, negative the points for consideration number 1 and 2, and allowed the appeal of the defendant, and consequently set aside the judgment and decree passed by the trial court and dismissed the suit of the plaintiffs. Full stop. It is this judgment of the first appellate court which is questioned and challenged by the plaintiff in this second appeal. Contending that the judgment and decree passed by the first appellate court, setting aside the judgment or decree of the trial court and dismissing the suit, is illegal, perverse, patently arbitrary, and has raised a substantial question of law that arises for consideration before this court. And thereby seeks this court to interfere with the judgment rendered by the first appellate court, set aside the same, and affirm the judgment and decree passed by the panel on the substantial question of law raised by the appellant plaintiff. Upon consideration of the arguments addressed by the learned counsel for appellant plaintiff and the learned counsel for respondent defendant, this court at the stage of admitting the appeal framed the following substantial question of law for consideration in this appeal. Whether in the facts and circumstances of the case, the first appellate court is justified in setting aside the judgment and decree dated 19/4/2006 in OS number 111 of 1996, and consequently dismissing the suit on the premise that the plaintiff had not proved the deed of sale dated 28/12/1948 at Exhibit P2 by producing evidence to believe that the land bearing survey number 177 has become survey number 267. Question mark. I've heard learned counsel for the plaintiff, learned counsel Sri M.S. Varadarajan for the plaintiff, and the learned counsel Sri Jayakirti, MC Jayakirti for the respondent. Respondents. It is the vehement contention of learned counsel for the plaintiff that the appellate court committed a serious error in holding that the plaintiffs failed to prove their title over the social property. Despite the fact that the defendant in the written statement has taken a plea that the sale deed was not acted upon, which would mean that the defendant has admitted the execution of the sale, but has failed to prove how it was acted upon. Thereby, it was the burden on the defendant to prove this fact as to how the sale deed was not acted upon. Learned counsel further contended that the appellate court committed an error in holding that the plaintiff failed to prove as to when the survey number 177 became survey number 267. Thereby, the defendant's contention that he is in possession and enjoyment of survey number 267 was rightly came to be accepted. It is the further contention of learned counsel for the plaintiff that the boundaries described in the sale deed did not tally with the boundaries given in the plaint, thereby giving rise to a doubt as to the identity of the property of the plaintiffs. Which may not be correct for the reason that boundaries given in the plaint was on the basis of the boundaries that existed as on date of filing of the suit in the year 1996. And it is not necessary that the boundaries would remain the same from 1948 to 1996. Learned counsel further contended that the First Appellate Court has erred in coming to a conclusion that the property, tuition property, is to an extent of more than 6 acres, whereas the recital in the sale deed property purchased was 4 acres 20 guntas. Learned counsel further contends the appellate court committed an error in accepting the case of defendant by holding that the defendant proved his title and possession over the property in his occupation in survey number 267. Whereas there is absolutely no oral or documentary evidence produced by the defendant to show that the defendant is in possession and enjoyment of the property bearing survey number 267, except to the extent of the statement pleaded in the written statement. So also, with regard to the partition having been effected by the father of the defendant, and to an extent of 1 acre 20 guntas fallen to the share of the defendant and his stepbrothers each, has not been established or proved by placing any material before the court, except the self-serving statement made in the written statement. Learned counsel further contends that the first appellate court has accepted the plea of defendant, whereas the defendant has not raised any plea with regard to identity of the suit shuttle property and its extent along with its boundaries, which came to be taken up for the first time before the first appellate court. Full stop. It was also not a pleading made before the trial court. It's further contended by learned counsel for the plaintiff that the that the defendant relied on the statement made by the plaintiffs that the defendant was put in possession of the suit shuttle property on vara basis, and thereby plaintiff has admitted the possession of the defendant over the suit shuttle property. And held that the plaintiffs have not proved as to when they took possession back from the defendant. The first appellate court has committed an error in not taking into consideration the fact that the physical possession of the suit shuttle property remained with the plaintiffs, and the defendant was only given permission to cultivate and grow the crops and to give 50% of the grain and 50% of haystack, which has been corroborated by the RTCs and the oral evidence adduced by PW2 and PW3. We'll stop there. Learned counsel further contends that though the plaintiffs have made a statement in the plaint with regard to the suit shuttle property having been given on vara basis to the defendant, that by itself cannot be taken seriously solely to decide the outcome of this suit, as sometimes pleadings are drafted by the counsels, which terminologies may be loosely used. The entire plaint averments and the pleadings will have to be taken as a whole rather than picking few words to decide the case, which is contrary to the law of pleadings. Learned counsel further contends that the First Appellate Court has not appreciated the materials placed on record, including the pleadings, and has not taken into consideration the fact that the defendant is an agent of the plaintiff. In respect of survey number 177, old in bracket, and new number 267. The First Appellate Court has also failed to take into consideration the pleadings in the plaint wherein at para number 6 of the plaint, the plaintiff has described the defendant to be in possession of the suit schedule property as a supervisor and labor only to provide the contribution to an extent of 50% of the food grains and hay stock, and nothing more than that. This aspect of the matter has been ignored by the First Appellate Court and thereby rendered a judgment causing miscarriage of justice to the plaintiff. Apart from this, it is contended by learned counsel for the plaintiff that there are several discrepancies in the evidence adduced by the defendant and then also an admission the fact that southern side of the suit schedule property is in possession of the defendant, including the DW1 stating on oath that there was no partition in the family. On the basis of these contentions, learned counsel for the plaintiff impresses upon this court that there is substantial question of law that arises for consideration before this court. With regard to the first appellate court having gone beyond the pleadings made in the trial court, and having ignored the materials placed on recording, including Exhibit P2, the sale deed, produced by the plaintiff to show survey number 177 old and new survey number 267, measuring to an extent of 4 acres 20 guntas, being sold by the father of the defendant, late Thirumalai Gowda, and the plaintiff being in absolute peaceful possession, enjoyment of the property, having given the possession of the same to the defendant, only to cultivate as a supervisor and labor, and hand over 50% of the food grains and hay stock on these grounds. The counsel for the plaintiff seeks to allow the second appeal by dwelling into the substantial question of law framed by this court by an order dated 1/4/2022. This being the state of affairs, the plaintiff has also filed an application before this court on 28/2/2022 under Order 41, Rule 27, read with Section 151 of the Code of Civil Procedure. For production of additional documents and to adduce additional evidence. 3 documents have been produced along with the application, namely certified Xerox copy of survey Tippani book in respect of survey number 177 having become survey number 267. Second, certified Xerox copy of survey sketch of Gomala survey number 177 changed as RE SY number 267, numbering 2 pages. Third, certified Xerox copy of detail of new survey number along with village map pertaining to survey number 177 and 267 of Moje Iligumba, Samattura Ramanagaram, Ramanagara Taluk, containing 4 pages. Full stop. by virtue of this application, plaintiff is taking out a case that survey number 177 became survey number 267, measuring to an extent of 4 acres, 20 guntas, in which the plaintiffs are in peaceful possession and enjoyment of the suit schedule property, which documents were unavailable with the plaintiffs at the time of the suit and before the first appellate court. And after tracing the same, are now seeking to produce these records, which will decide the case, as it is the crux of the matter as to whether survey number 177 became survey number 267 in due course of time. Stop. Is the objections to these applications have not been filed in writing. However, learned counsel for the defendant orally objects to the application being barred by time and not maintainable at this later stage of second appeal, and no material is placed before the court as to why these documents could not be produced either before the trial court or before the first appellate. Full stop. And also, learned counsel for the defendant contends that the documents that are placed as additional documents are without any basis or of pleadings. Full stop. Per contra, learned counsel for the defendant vehemently contends that the suit filed by the plaintiff is not maintainable in law, as the plaintiff has not come before the court with clean hands. And even according to the plaintiff, there is no proper description of the suit schedule property, and no pleadings to the effect that survey number 177 was converted into survey number 267, and as to on which date the said conversion took place. Neither is there pleadings, nor is there any material placed on record before the trial court or the first appellate court to show the conversion or changing of survey number 177 old to survey number 267 within bracket new. Full stop. Learned counsel further contends that even according to the plaintiff, as per exhibit P2, there is absolutely no mention of survey number 267. So also in exhibit D2 to D4 produced by the defendant, there is mention of only survey number 267. No, survey number 267, D2 to D4 in the name of your grandfather, in the name of father of defendant, late Tirumale Gowda. The plaintiff has also not produced any document to show that the plaintiffs are the owners of survey number 267. Learned Counsel further contends that the boundaries described in Exhibit P2, the sale deed, alleged sale deed, and in the plaint do not tally with each other. Full stop. Learned Counsel further contends that even according to the plaint averments, the plaintiff had given the property on vara basis to the defendant. But however, there is no termination of the lease. And so also, there is no pleading as to when the defendant got into possession and when the plaintiff took possession from the defendant. Stop. Learned Counsel further contends that the theory floated by the plaintiff falls flat on the ground with regard to survey number 177 having been converted to survey number 267 for the reason that survey number 177 is still in existence and the same is not deleted from the revenue records. Full stop. He further contends that if the case of the plaintiff is accepted, then the question of survey number 177 continuing on the records, revenue records, would not arise as the same has been converted as per the plaintiff to survey number 267. Learned Counsel further contends that there is no illegality or perversity in the judgment rendered by the First Appellate Court, as it has considered all the materials on record and the arguments addressed by both the parties. And taking into consideration all the aspects put forth by the parties, the First Appellate Court has rightly come to the conclusion that the trial court committed an error in decreeing the suit of the plaintiff, and held that the plaintiffs have not been able to prove the fact as to when they took possession from the defendant after the alleged termination of tenancy. Thereby, the judgment rendered by the First Appellate Court is not tainted with any illegality or perversity for this court to consider substantial question of law as, according to the defendant, there is no substantial question of law that arises for consideration in this second appeal. Stop. Para. Learned counsel for the defendant further contends that this court is dealing in the second appeal under section 100 of the Code of Civil Procedure. And this is not an appeal, first appeal to consider the evidentiary facts of the matter, and evidence adduced by the parties by reappreciating and reanalyzing the materials on record. He also contends that in second appeal, the scope vested under section 100 CPC is very limited and narrow. Even if this court comes to an opinion that there could be a third view or a third opinion apart from what is stated by the trial court and the first appellate court, this court in second appeal cannot put forth its opinion cannot put forth its third opinion to reverse the finding of the first appellate court, which is the last court of fact finding. Full stop. He also contends that nothing prevented the plaintiff from relying on the documents which is produced as additional documents before this court at an earlier point of time, or amending the pleadings in the plaint as canvassed before this court. Full stop. Learned counsel for the defendant relies on the following judgments in support of his case. Defendants. Before the contentions, counsel for the plaintiff relied on the following judgments. Having heard learned counsels for the plaintiff and learned counsel for defendant, and having perused the original records, and after giving the thoughtful consideration of the entire material on record, including the vehement submissions of the learned counsels for both parties, on the substantial question of law framed by this court on 1/4/2022. It is to be seen as to whether the plaintiff has been able to make out a case to establish that survey number 177 old has been changed and converted to survey number 267 within brackets new, which is the crux of the matter. Stop. It is no doubt true that this court, while dealing in second appeal under section 100 of the Code of Civil Procedure, is not called upon to reappreciate the evidence and express its third opinion, if any, unless there is some perversity or illegality or ignorance by the either of the court below to any relevant issue and facts in issue. In the present case, the trial court has decreed the suit of the plaintiff, whereas the first appellate court has reversed the decision of the trial court, set aside the judgment and decree, and dismissed the suit of the plaintiff. Full stop. As stated earlier, the entire case of the plaintiff boils down to the point as to whether survey number 177, measuring to an extent of 4 acres 20 guntas, purchased by the plaintiff, father late Mugaya, from the father of defendant late Trimale Gowda, which is produced at Exhibit P2. Would establish the title of the plaintiff for granting the relief of declaration and consequently for the relief of permanent injunction. While considering these aspects, it would also be relevant to note the defense taken by the defendant in the written statement. With regard to execution of the sale deed, Exhibit P2, by the father of defendant late Trimale Gowda, in favor of the father of plaintiff late Mugaya. The written statement The defendant has taken a plea that the sale deed so executed is a concocted and got up document, and therefore the father of plaintiff's late Mugaya never acquired any right, title, or interest over the suit schedule property. And so also he was never in possession. So consequently did not acquire any right, title, or interest. We continue in the afternoon, Mr. Whether you have two properties now or then why should you? Yaru. The property is one. Defendants are two. And they are interfering with your property. That is the plea of defendant. Your case is that you are the owner of 750 square feet, 30 by 25. That is only one. It's not two properties. Yes. I will dictate if possible in that. Once I finish this, I will dictate in that. Serial number? Ah. All right. Admission, you want to argue? All right. TLR, trial court records are after vacation you want. There are counsel for the appellant present before the court. He expresses some difficulty today to argue in the afternoon. Hence, at her request, release this matter immediately after the Dasara vacation.
tally ಮಾಡಿ. One more application of complaint ಮಾಡಿ. Plus, it is. Plus purchase.
ಅದರಿಂದ proceedings are each one.
ಅದು ಇನ್ಫಾರ್ಮ್ ಮಾಡುತ್ತೆ.
Court officer? Court officer? Court officer? ನಮ್ಮ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಬಂದಿಲ್ಲ ಮೇಡಮ್, ನಮ್ದು ಪ್ರೊಬೇಟ್ CP 17 ನಲ್ಲಿ
ಬಂದಿದೆ ಮೇಡಮ್.
17
ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲ ಪ್ರೊಬೇಟ್ CP 5 of 23 ನಲ್ಲಿ ಇದೆ.
ಓಕೆ
17 ಅಲ್ಲಿ ನೀವು 16 ಅಲ್ಲಿ ಹಾಕಿದೀರಾ, ಬೈ ಮಿಸ್ಟೇಕ್ 17 ಅನ್ಕೊಂಡಿದೀರಾ ಅನ್ಸುತ್ತೆ ನೋಡಿ.
ಇಲ್ಲ 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 16 ಬೇರೆ ಕೇಸ್ ಇದೆ, 17 ಕೇಸ್ ಇದೆ.
17 ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತ ಮೇಡಮ್, ಅವ್ರು ವೆರಿಫೈ ಮಾಡಿದ್ದಾರೆ, ಬ್ರಾಂಚ್ ಅವ್ರು ಇದಾರೆ, ಬೇಕಾದ್ರೆ
ಇಲ್ಲ ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಇಲ್ಲ, ನಾನು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, 17 ಅಲ್ಲಿ ಐ ಫೈಲ್ಡ್ ಇಟ್ ಲಾಸ್ಟ್ ಮಂತ್ ಪಬ್ಲಿಕೇಶನ್. ಅದು ಎಲ್ಲಿ ಕಳ್ದೋಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಸೊ ಐ ವಿಲ್ 16th I filed yesterday. That is, time is there in that. There is no mistake in that. Because 17 is husband's case, 16 is wife's case. Madam, 17 is husband's case, 16 is wife's case. Ibru ಲೋಬೋನೆ, same name ಬರುತ್ತೆ.
ಅವರು ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಏನು ಬರತ್ತಲ್ಲ ಪೇಪರ್ಸ್ ಹಾಕಿರೋದು ಡೀಟೇಲ್ಸ್, ಅದನ್ನೇ ಪ್ರಿಂಟ್ ಔಟ್ ತಂದು ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ನನ್ಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. ಮೇ ಬಿ ಬೈ ಮಿಸ್ಟೇಕ್ ಇಟ್ ಇಸ್ ಲಾಸ್ಟ್ ಇನ್ ದ ಫೈಲಿಂಗ್ ಕೌಂಟರ್.
ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಅಲ್ಲಿ ನಿಮಗೆ ಏನಾದ್ರೂ ಫೈಲ್ ಮಾಡಿರೋದಕ್ಕೆ
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಮೇಡಮ್. ಸರಿ, ಐ ವಿಲ್ ಬ್ರಿಂಗ್ ಇಟ್ ಅಂಡ್ ಕಮ್. ನೋ ವಾಟ್ ಹಸ್ ಹ್ಯಾಪನ್, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಮೇಡಮ್ ಅದು.
ಓಕೆ ಮಾ 2:30. ಓಕೆ.